My name is Jennifer Chaney. I'm the real estate professional here at Vesta. I've been in the business for 22 years and I specialize in divorce real estate. So it is a thing and there is a certification for that. And after going through my own divorce, I found Vesta, and this hub really helped me through that too. And then I changed my business model and really help people throughout that process. So Vesta has been around for, gosh, over 15 plus years now, right, guys? Over
Yep,
15.
something like that.
We are all throughout the United States, and we really truly come from a place of service, every single one of us, because we're passionate about this space and passionate about helping you through this process and empowering you to possibly divorce differently. It's usually caught up in a toxic feeling of divorce. And while there is still that, and there's a lot that happens, we try to give you as much information and empowerment as possible to help you gain that knowledge to maybe move through a little bit easier. So, everyone here is really passionate about this and gives a lot of their time to Vesta. We show up every single month with different topics. Again, it's free, you can just join. But one thing I want to share with you is if you are local to San Diego, we just started doing in-person sessions as well. So our next one is March 18th. If you are interested, you can go on the Vesta website and sign up for that. It's located in Carlsbad from 6 to 7:30, and it's really a divorce resource night. It's a way for you to get personally with us, face to face. We cover the entire A through Z of topics because it's really tailored to whoever's in the room at that time in person. And then again, we do these monthly live so you can be all over the United States and join. Some of our professionals only deal with local connections as far as we can only service you locally, but a lot of us can help you all throughout California and maybe even other areas as well. So I think you'll get a lot of information from tonight. And then again, just post your questions in the Q&A so that we can get to those at the end. So first, what I'm going to do is just introduce the crew and who you're hearing from tonight. Ken, why don't you start?
Sure,
Tonight is about tax and legal considerations,
sure
divorce.
thing.
So Ken is the first first one to introduce.
All right. Good evening, everyone. Thanks, Jennifer, and thanks for being here. As Jennifer said, I'm the attorney in the hub. My entire practice is dedicated to family law. So all I do is divorce cases. And whether it's from the beginning, with a petition or a response, and dealing with all the issues during a case, child custody, visitation, child spousal support, dividing assets and debts, all of that. And I also deal with the cases that arise after a divorce, because sometimes people need to modify visitation agreements or schedules and support. So that's the realm of what I do. I have cases in all of the San Diego County courthouses, and I've been doing this for 26 years. So looking forward to sharing some information with you all tonight. I guess with that, I'll pass it off to the other part of our fantastic real estate team, Emily.
Thanks, Ken. Hi, everyone. I'm Emily Palmer, a broker owner of Trust Funding, and I'm a certified divorce mortgage specialist for the Carlsbad Hub. And we all as a team really understand that this is one of life's most challenging times and what the transition that you're going through. Like what Jennifer said, we really want to empower you with what your real estate options are. One of the first things that I offer is just a free consultation just to see where you're at with things. We kind of work with it as a discovery period to find out if more beneficial to sell the property, to keep the property, or possibly defer the property. We go through just a few questions and explore what your income analysis looks like. We review credit. What does the payoff look like to a spouse or your partner? What does the cash flow look like? And what's important is that you're still maintaining that same lifestyle with yourself and your children that you had before the divorce happened, and if you are taking over that property. So there's lots of moving pieces when it comes to real estate and finance. And that's our goal, is just to make sure that this transition is as smooth as possible. And we have just the most amazing team to help support you through that in every way possible. And then I'll introduce Cinda.
Thank you.
I'm
Right.
Cinda Jones. I've been working with couples and individuals for 25 years. I do divorce only. I don't do traditional financial planning, but I help people look at what their sources of income might be and all the tax questions and that kind of thing. So it's always a pleasure to be part of the Vesta group because we know and trust each other and work real hard to help answer questions and take care of people in the right way. And that's really important when you're getting divorced. You need to be able to trust the people you're working with. So thank you for being here with us. And it's our pleasure to have you as our guest. Thank you.
All right. So how this is gonna work, guys, is we're gonna go almost like a round robin. Ken's gonna start first with the legal side. We're gonna bebop over to Cinda for the financial side, and then we're gonna end with Emily and I on the real estate end. So again, any questions that you have, please put it in the chat box. We will get to those at the end, and we'll each kind of round robin here for about 10 minutes. All right, Ken, take it away.
Great. Thank you. Okay, so as far as the legal side of things, I think the best way to go about this is to first give everyone an overview of the divorce process, because that really kind of shapes so much of what you have to decide on what to do. And if you, the better you understand the process, the better decisions you can make. So we'll start with that. I'm going to attempt to share my screen and see if that works. Can everyone see that? Okay, good. All right. So assuming everyone can see my screen, it's just this diagram that shows it outlines a divorce process. And I'm also going to interject as I speak about this the different ways you can approach a divorce case, mainly through heavily litigated, which is my world, and mediation. Typically, we have Laura who's here. She's our mediator, and she can give more details about that, but I'll talk about it as well. So, the first step in any divorce case, it doesn't matter if it's the most friendly divorce that ever happened or it's the ugliest, most nasty divorce that ever happened. It all has to start in the same place, and that is by someone has to file a petition in their local courthouse asking for a divorce. And with that, they have to file a $435 filing fee. So that's what starts a divorce case. That's step one. And then it also has to be served on the other party. And the thing is, a contrast here is if you're mediating where you're getting along and cooperating with one another, that can be a very easy process, meaning you can meet at the mediator's office or the mediator could just hand it to the other spouse and then that's done. If you're litigating and it's a very contentious divorce, that can first step can be very complicated because a lot of people try to avoid service. You can have process servers hanging out in airports and parking lots trying to hunt someone down. That can get painful, but unfortunate reality sometimes in contentious divorces. So filing it and serving it is step one. Technically, once the petition is served on the other side has 30 days to respond and file a response with the court. Otherwise, they could technically be sent, a default judgment could be entered where if they didn't answer, the person who filed the petition could be granted what they asked for in the petition. I'll tell you that that's usually not granted automatically, but I will say from a legal standpoint, if someone gets served with a petition and there's no agreement to potentially delay having to file it, always make sure you file your response to protect your legal interests. Especially if you're litigating, without question, you're going to want to file a response if you get served with a petition for divorce. In the mediated context, that can be a very easy situation to deal with because typically in mediation, since the parties are cooperating in getting their divorce resolved in mediation, many times the person, as I said, who's served with the petition, or the spouse who gets served by just having it handed to them, the parties will agree that they don't have to file a response because in California, technically, if the parties agree, the person who was served with the petition does not have to file a response, and you can actually get your divorce judgment processed without ever having filed a response. And the agreement will also be, if you're in mediation, that if for some reason the mediation does not work out and you end up having to litigate, the person who is responsible for filing the response, they'll be granted X amount of weeks or months to file a petition, a response without the initial filer trying to get a default judgment against them. So obviously that whole process is a lot more amicable and painless if you're doing the mediation route. Okay, so what I just talked about was the first step in any divorce, which is filing and serving the petition. That opens the divorce case, and you're off and running. And the divorce case is now active in court, and now you got to go to step two. Step two is in the second column, which you've titled Evaluate. And that consists of these financial disclosures that are required under California law. In California, it's the law literally under the family code where there's certain financial disclosures that have to be exchanged by both spouses. And if those don't happen, a judge literally is not permitted to grant a divorce. So it's a very important step. The also to keep in mind about this step, the objective of it is to, for both sides, to fully understand the entire financial landscape. Okay. And I think the best way to explain it is to explain the forms that are involved. California, they love their forms in the court system, and sometimes they're a pain, but sometimes they can be helpful in terms of focusing on what's important. And this is one of those occasions. One of the forms in these mandatory financial disclosures is called the Schedule of Assets and Debts. And it's the FL142. You can Google it. It's a free form online. And as the name implies, both sides are required to complete this and list out all their assets and all their debts, and also to attach the most recent statement for each of those assets and debts. So if there are credit cards, bank accounts, you've got to attach, not only do you have to list them, you have to attach the most recent month statement. If there's car loans, same thing. If there's a house, attach the mortgage statement for the most recent month, so on and so forth. The other form is called the FL150, and that is called the Income and Expense Declaration. Again, like the name implies, it actually helps you understand what's in it. You've got to list out all your income and all your expenses. And along with that, you also have to attach your last 2 months of pay stubs if you're a W-2 employee. If you're an individual that owns your own business or you have different types of compensation, you might have to attach different schedules from your tax returns to at least provide some backup as to what your income is. Now, as I said, the whole point of that process is so that everybody has a full understanding of what the financial landscape is. And it's important because, number one, with the income and expenses, that's necessary information so that the parties can figure out how is support going to work, child support, if applicable, and spousal support, because those numbers and that information is going to be used to calculate those support figures. The other factor is the Schedule of Assets and Debts. That's going to provide the landscape and the bucket, if you will, of community property, because you need to know what's in the community bucket that has to be divided in the divorce. So a word about how this all works out, because I get a lot of questions about it, is what if the other side's not being forthcoming or just being shady and trying to hide things? That's a good question and a valid concern, but I will say this. First of all, it depends on what context you're in. If you're litigating and it's contentious, yeah, you may run into that situation where somebody's not being forthcoming, and you may have to resort to other means by which to try to find the information, which is called discovery. The law provides you the ability, if you're trying to get more information from the other side, to serve them with demands for production of documents, interrogatories. You can even make them sit for a deposition and answer questions under oath. You can also, your attorney can send subpoenas to different financial institutions. So all of that's available. I'll say it's very expensive, so you need to really do a serious cost-benefit analysis if you're going to go down that path. But there are tools by which to obtain information you believe is not being provided. One thing I will say about that is it also can be very helpful to have someone like a CDFA like Cinda, who understands all the intricacies of the financial aspects of a divorce, because they can review documents, and because they've got trained eyes to know what to look for, they can see in different documents such as tax returns or W-2s, what have you, and see what might be there that you might need to get more information about. So she'll talk more about that when she speaks, but I just wanted to put that plug out there at this point. The other thing I'll talk about is mediation. If you're in the context of mediation and you're going through this process of the financial disclosures to one another, the mediator is not just going to sit back and just take people's word for whatever saying they're disclosing. Because the mediator, like Laura, is an attorney. She has to do her job to make sure that whatever negotiations happen are happening in a fair and proper way. So if she or any mediator in a divorce case feels or can detect or sees that there's something that's not being disclosed or there's missing information, she's going to hold the parties' feet to the fire and make sure that that information gets provided. And if things reach a point where one party is simply refusing to cooperate, that mediation probably isn't going to go forward and it's going to end up going to litigation. But the point I'm trying to make here is that there are mechanisms by which you can verify and ensure that you're getting all the financial information you need when you're making these decisions and knowing what you need to know in order to negotiate or if you have to litigate the divorce going forward. Now, other point I want to make about this is that what constitutes the community. As I said, the purpose of this is to figure out what's the whole bucket, what's the whole world of community assets that we need and debts that have to be divided. It's important to remember what constitutes community property. Now, we all know, we all hear all the time that California, we're a community property state, and that means everything has to be divided 50-50. But we need to also be cognizant of what is the definition of the community. And what that is, anything that was acquired between the date of marriage and the date of separation. That may sound simple, but it can be complicated because for a couple of reasons. First of all, there are two exceptions to the community property rule that anything acquired during marriage is community property. Exception number one is if either spouse receives a gift that's actually technically their separate property that's not subject to community division. The second one is if they receive an inheritance during the marriage, even if they get it during the marriage, if they receive that inheritance, that is their separate property that is not subject to being divided in a divorce. But of course, with every exception or rule, there's a but. And the but is this, is that yes, a gift or an inheritance received during the marriages is that spouse's separate property, but it can lose that characterization of separate property. And the way that could happen is if it, for example, the legal term gets commingled, meaning mixed in with community funds and used for community purposes to the point where the law will essentially presume that it was a gift. A classic example is, let's say someone gets a chunk of cash they inherit from a relative that passes away. They put it in a joint community account and they end up using all of that for just routine community purposes, groceries, utilities, the mortgage, so on and so forth. After a while, it's going to essentially lose its character as separate property. But there's also the person who may try to claim in a divorce that it's separate property. They have the ability to trace it if they can. You'll hear this term tracing. And if they can trace the funds that were used back to a separate property source, they may be able to claw it back and say there was a separate property. The bottom line is it's easier to do it if there were just a few transactions or it was kept segregated. The easiest case is, which happens sometimes, someone receives a separate property amount of cash, they put it in a brokerage or some type of account that earns interest or in the stock market, and they just leave it there and they never touch it. That's the easy call. But there are also other situations such as where, let's say, someone receives that amount of cash and they use it to add a pool to the community house. It is used, commingled, and used for community purposes, but because they can trace that amount, and it was just pretty limited transactions, they have a better chance of proving it was separate property. So it's a case-by-case basis. So be aware of those exceptions. The other thing to keep in mind with regards to community property is the date of separation. The date of separation is important because that's the end of the community. And, some might think that the date of separation is easy to figure out, but sometimes it's not. It's significant because, as I said, it ends the community. And the meaning of that is that any assets or debts acquired by either party or any income that they may receive after that date of separation is no longer community property and is no longer subject to division. So sometimes you get a case where one party received a big work bonus from their employer, and they're obviously arguing that, yeah, that was after the date of separation, I had to divide it. So as you can see, it can sometimes become a point of contention depending on the circumstances. It's in any case, even if there isn't something major to argue about regarding data separation, it still has to be decided because to get divorced, you're going to have to need to identify what that data separation is. And the legal definition is not terribly helpful. It says something along the lines of the point in time where either spouse, through their words or actions, determined or demonstrated that there was a final break in the marriage. If you listen to that definition, you can tell right away it's extremely subjective. It really depends on the circumstances. Sometimes it's easy to pick out. Sometimes in a situation, one spouse discovered the other was unfaithful, things blow up, and that's that. Okay, they point to that time. Sometimes the parties will point to that there was a day when one spouse picked up and just moved out of the house. Sometimes they'll pick that. But many times it's just not so easy to figure out because sometimes people still stay living under the same roof to save costs. And bottom line is be aware that you're going to have to figure out the data separation, whether it's by agreement or negotiation, and hopefully not, but I've had cases where I've gone to trial on the data separation. But at any rate, it's going to have to be figured out. Okay, so we've gotten through the second phase of this evaluation, and I've talked about how that can happen differently in mediation versus litigation. And the next step is basically you've got three ways to go about it. If you're in mediation, once you have all of this financial disclosure process complete, it's time to start negotiating and mediating with the help of the mediator who will assist you in coming to an agreement on how to get every aspect of the divorce agreed upon and then finalized with a settlement agreement. It's called a marital settlement agreement. And that'll document all the terms of settlement with the judgment forms will be signed by the parties. The mediator will then take care of filing that with the court. Well, option two is the other spectrum of things, which is a lot of what I do, which is litigation, where once you have all that information, then it's time to go to court and start arguing about stuff the important issues. It can be custody visitation of the children, but typically also child support, spousal support, how to divide the assets and debts in a case, things of that nature. And if you're not coming to any agreements, you're going to court to present arguments to the judge and go to hearings to get the judge to give you decisions on how all these assets and debts are going to be divided. And ultimately, what you'll end up doing if you cannot come to any agreements is the case will be set for a trial where all of these issues will ultimately have to be litigated in a trial. And then you'll get a divorce judgment when the trial is complete. So that's the opposite end of the spectrum for mediation. The middle ground, I guess, hybrid, if you will, is sometimes people don't get along good enough to mediate, but they also don't want to be going to court and spending all the money to fight about every little thing. So what they'll do is, and I have cases like this where they'll each have an attorney of their own, and through their attorneys, they'll go back and forth, negotiate terms of settlement, and ultimately, by negotiating through their counsel, come to an agreement which is memorialized in a marital settlement agreement. And then a judgment ends up being signed by everyone and filed with the court. It's not as economical and as quick as mediation, but it is far less costly and time-consuming than full-on litigation. So a couple other points I want to make real quick is regarding the typical issues that end up getting litigated heavily, but can be dealt with a lot easier in mediation if you can. And first of those is child custody and visitation. What I'll say about that in the litigated context is if you end up not being able to come to an agreement between the spouses, the process is this. Someone has to file a motion with the court asking the judge to issue orders on custody visitation. What'll happen is he'll be issued two dates. The court will issue two dates. Date number one is family court services mediation. The parents only, even if you have attorneys, parents only can go. The attorneys aren't allowed. The parents have to go meet with a court-appointed mediator, and the mediator will try to get them to come to an agreement. But if not, then they'll listen to each parent and hear them out on what they want as a parenting plan and why. And then based on that, the family court services mediator will come up with their own custody visitation plan, send that to the judge and the parties. And then the second date is when the parties show up to court, have to go to court in front of the judge, and the judge has the report from the mediator, And the judge will simply say, what is it about this report you'd like and do not like? Tell me why. And based on the input from the parties or the counsel, the judge is going to issue a custody visitation order. So it's a real dissatisfying process. And I say that because it's a 20-minute hearing. There's no witness testimony. So it's really sparse on details. And a lot of times it's really not going to take into account important stuff regarding the children. You'll be far better served if you can come to an agreement to mediation where you'll have a much more robust and personalized parenting plan. The other item that tends to get litigated a lot is spousal support. Child support, generally not, because it's really easy to figure out. And what I mean by that, it's determined by a state mandated computer program. You plug in the timeshare and the parties' incomes and some other financial information, and whatever that is, it is what it is. But spousal support can get very difficult. And what I mean by the reason that is there's two phases, first of all. Phase one is what they call temporary spousal support, and that's what applies from the time a divorce case is filed up until the divorce judgment's entered. And that part is easy to figure out because that same computer program I told you about, whatever the amount that puts out, that's what the amount's going to be essentially. But where it gets really problematic is what they call long-term spouse support, and that's the amount that applies from the time a divorce judgment's final into the future. And that's difficult because under the law, that computer program that makes it easy, that can't be used anymore. And a judge has to apply a whole list of factors and then come up with an amount that they think is fair. So it's incredibly subjective and tough to figure out. In the same way that it's tough to deal with this at court hearings in front of a judge, you get your 20-minute hearing if you're going to argue about that, and the judge is going to make a decision based on what they think is fair. But again, if you can come to an agreement at mediation, you'd be better served to go in that route if you can reach a compromise on that, because you can get much more in depth and a more personalized approach to dealing with the issue of long-term spousal support. So that's an overview of the legal process when it comes to divorce. In terms of tips, I'm going to share two quick tips here. And they're mostly from the context of my world, which is litigation. If you're litigating in court, I'll say number one, don't go and litigate and file a motion and fight on an issue in front of a judge unless you understand exactly what your objective is. And that may sound simple, but it's surprising how many people don't follow that. And I always use this example because I've seen it so many times. There'll be times I'm in court waiting for my case to be called, and parties will come up where somebody's filed a request for order to modify support, whether it's child or spouse support. And it's clear as soon as the hearing starts, they haven't prepared or understood what they're trying to do. They just think, I need to modify it. But they should have done the calculations and homework. Obviously, they're coming in there asking for more. And then what happens is, because they haven't looked at all the documentation or taken the time to do the homework and run the calculations, I've seen people coming in asking for more in support, coming away with less because they didn't prepare or understand really how they were going to get to the objective. So that's point number one. My second tip is to resist the urge to just fight about every little thing. I get a lot of times I'll hear someone say, I need to take this to court for the principle of it, or the other side needs to be taught a lesson. You really need to sit and do a real legitimate cost benefit analysis on whether it's worth it to go to court, and you're not just trying to go there because emotions driving you to it, or you're just trying to make a point, because it's just not worth it most of the time. There's a story we all tell because it was true, but that illustrates this. Is there was a divorce case, and divorce had been final, but wife found out that husband in his new job was receiving this allowance to his employer for his car. So she believed that because he was receiving that, her support needed to be increased. Point is, they went to court, she filed motions, there was thousands spent legal fees on discovery, so on and so forth. They finally get to court, and eventually, yeah, there was a slight increase in the support being paid. But when you match that up against the thousands of dollars in legal fees that had been spent to get there, it clearly was not a worthwhile cost-benefit analysis. So that's my second point to share with regard to the legal process. So that's been my overview. With that, I will now pass it over to Cinda for the financial and tax aspects.
Thanks, Ken. Good job. Tough subject. So let's talk about some of the things that we published that we were going to be discussing in the context of divorce. I want to reiterate and say again, as Ken did, know your facts and an estimate of outcome because people can spend a lot of money. So you have to look at the cost benefit ratio. If you spend $5,000 on a $1,000 financial difference, then by the time the costs for attorneys and going to court ramp up, then you're in a losing position. The courts, it's hard to get trial dates. They're pushed out a long time in San Diego County. I've heard sometimes where it can be a year. So everything that you can do to talk to each other, even if you don't like each other anymore, try not to bring up past pain because those discussions aren't going to move at least the financial picture forward. So you need to know the financial facts and gather all the information, all the assets, all the debts. You're going for the declarations, you're going to have to provide copies of statements. One of the ways that divorce can be way too expensive, very unnecessarily, is when one person will say, for example, that's my 401k account. It's got my name on it and I put my paycheck money in it. That's not the way the state of California sees it. Your contributions to your 401k, the houses that you bought, the investments that you made with the money that you are making during the marriage belongs to the community. And it doesn't matter if it's in your name alone. That isn't the way California divorce works. It's community property. So when people dig in and say, I don't have to tell you, that's in my name. They're completely missing the mark, and in the end, it's just gonna cost more money. So when we know that conflict, as it escalates, it also escalates the dollars. And I know it doesn't feel good. Anyone who works in divorce knows that it's not a place where people gladly give in or have other considerations, but it's in your best interest to at least explore alternatives. The assets and the debts that you have, each one of those things are a trading chip, and you can maneuver your assets and your debts around and look at different alternatives. Sometimes one of the things that I do is put proposals side by side, and then we can see where people might match up with an idea and where they may be very much on the opposite end of what they might do. But the more you talk about it and the more you look at alternatives, the better the dialogue will be and the sounder your decisions will be. When two people, if possible, not always possible, but if possible, they can discuss alternatives, then they will each have had ownership about the outcome. And when you own the outcome, you've done the very best you can, then people are less likely to go back to court. Sometimes we see situations where someone has been entirely had all the control over the finances and the other person doesn't know anything or very little. I find sometimes that they know more than they think they know about it. But nevertheless, for the person who's been in charge, they can feel that they're being criticized. They can feel that they're being judged to be not forthcoming when in fact they're just being asked for information. The court requires a lot of information, a statement, details. Sometimes we have to go back, we have to sort out what was community and what was separate. Sometimes we have to have a better understanding of investments or life insurance. And that isn't meant to call someone a problem person or to call them wrong. It's because you're in a legal process and these things need to be known so that people can make informed decisions so that they have ownership of the decisions and then you can both move forward as best you can. The conundrum of supporting two households with essentially the same amount of money at the beginning of the divorce is very painful. It's very painful for both people. And it's human nature sometimes for us to say, but I should have, this isn't okay. In California, you're going to have to share whatever income is available. It's called income available for support. And as time goes on, there can be adjustments in that because support isn't forever. Also heard people say sometimes, okay, then that person's going to pay me support for the rest of my life because we were married for 30 years. Not necessarily. Probably not, because people are allowed to retire and the assets are split. So support is unlikely that it will go on forever unless there's a big disparity of assets. Maybe someone inherited income is subject to income available for support. Sometimes people don't know that either. You may have a rental property that you inherited. You don't have to share that rental property. Somebody doesn't get half of that. But if you're getting income from, that's income available for support. In a business where people will give us a profit and loss statement, we need to see balance sheets, we need to see tax returns, personal tax returns, business tax returns. And when somebody has a business and they're getting certain perquisites from that business, like an automobile or a cell phone or vacations, or sometimes people run their groceries and their clothes through their business. Those are add backs to the profit and loss for the business. Sometimes people will say, here's my profit and loss. The business is a loser. But when you go through the general ledger and you see the benefits that are coming from the business that are being written off on the tax return, who's to judge that? Not me. But it is income that's available for support. So know that there are alternatives and there are ways that looking at assets and debts that may be out of our everyday circumstances, or maybe even outside of what we might think is logical and makes sense. Sometimes people will say, that doesn't make any sense. And maybe it doesn't, but maybe that's the law. The thing is, if you're doing mediation and you're working together, you can make other arrangements that might not happen in court. If you go to court, the judge they take care of what the law is. And if you can't agree, the judge has a plan for you. So you can make arrangements with each other that might never happen in court. We see people that might trade retirement accounts for the equity in the house. You have to factor in the tax consequences of that because those dollars aren't the same. The money in retirement accounts, the taxes have been deferred. If somebody takes the money out of that, they're going to have to pay taxes. And so that isn't the same kind of money that is in the equity of the house. So we have to talk about what are the tax consequences and what does it mean? You want to know that with a 401k, you can give somebody all of or a greater share of a 401k because in equalizing the assets and debts, then they might want to use some of that money. The non-employee can use a distribution from a 401k and they have to pay taxes on it, but they don't have to pay the 10% penalty. If the employee takes that money out and then hands it to the other person, if they're younger than 59 and a half, they're going to pay taxes and penalties. So it doesn't happen very often, but there have been cases where couples have said, okay, I'll give you the 401k or I'll give you the IRA or something like that. And then they just go ahead and just do it. But if you do these things in the box under the umbrella of a divorce, divorce sometimes has different tax rules. So, for instance, if one person says they get the house, they get 100% of the house, that isn't treated like a sale. It's a transfer of an asset under the umbrella or in the divorce box, and there's no tax consequences for that. One of the things that you want to be aware of, if you're a little bit older, 55 or so, in San Diego County and some other counties in California, if you take the house, then you get the lower tax, income tax, right? If you sell it there or you go and buy something else, then your property taxes are going to be higher based on the sale price. If one person is going to take the house, then they're going to get probably a lower property tax consequence, and that can be factored into the marital settlement agreement where the other person is then going to have to go out and buy something and pay a higher property tax. The other thing that I sometimes see when people are contemplating selling a house, they're using a number that isn't the basis. They'll say, okay, the fair market value is 2 million and we have $1 million mortgage, so that's $1 million profit. Doesn't work that way. If you've got a $2 million property and you paid 500,000 for it and there's no additional capital improvements, now you have a capital gain of $1,500,000 and you will pay capital gains on that. And the cost of capital gains can be really high. The percentage for capital gains depends on your other level of income. So the higher income tax rate that you pay on your other money, that affects the amount of money in terms of capital gains that you pay if you sell a house. In connection with knowing and understanding what's happening, you want to know if you sell not just the realtor costs, but what are the potential capital gains costs. You want to know what the basis is of a residence. What did you pay for it? And did you make capital improvements that might increase the basis and lower the taxes? If you have a rental property, you know you're going to be taxed on whatever the gain is in that. But you're also, if you've taken depreciation, you're going to have a depreciation recapture amount. So you want to map those out carefully. You want to do a net cash flow analysis. Can I afford to stay in the house? It's often very upsetting to one person or maybe both to lose the house, and they may want to keep it, but they can't really afford it. And within a year or two, they're putting it up for sale. And so it's better to have a clear picture of how that's going to work and what the consequences might be. Because if you sell a house together, you have a $500,000 exemption against the capital gains. If you sell it by yourself later, it's $250,000 exemption against the capital gains. So you want to do a net cash flow analysis. What will be the source of all income? Your wages, support, maybe you have investment accounts or rental properties. What will that be? What will your living expenses be? What will your taxes be? And then is there anything left over? And you want to look at how you're going to file your taxes. So you're going to file a single. Do you have children? Do you have dependents? Will you be able to file as a head of household? You can postpone the divorce. You can you can take care of everything in connection with the divorce and put it on the shelf for a little while if you want to file a joint tax return, if that would give you more money. So you want to put the different ways that you could file tax returns. You want to put those side by side and see where the sweet spot is for the taxes, because why give the government tax money when it'd be better off in your pocket, right? So do a net cash flow analysis, do an equalization analysis of all the assets and all the debts, and make sure that you see and know, understand tax consequences of selling, keeping. What does that mean? Sometimes people have restricted stock and stock options, and there's certain formulas that we use for those. I think it's always a good idea to see the year-end pay statement for someone if they're an employee, because then you can see if they've gotten stock options or restricted stock. That'll show up on the pay statement. Looking at a W-2, in my view, is not enough. You need to see 12 months of pay statements, and you need to see a year-end pay statement, so you're capturing everything. And you can change the exemptions that you claim on your tax returns. Sometimes people want to talk about This is what I bring home, so that's all I have. Maybe you could change your tax exemptions, or you may be having withholding for certain items on your wages or from your company that you just won't be able to do for a while. People have adjustments that they have to make, usually, particularly at the beginning. And then as time goes on, they sort that out. Somebody makes more money, and circumstances can change, and support can always change. If there's a change of circumstances, you can go back to court and ask for some changes. But as Ken said, you want to be careful about that. If someone gets bonuses, have restricted stock options, some extra pay, that's calculated separately from spousal support. It's sometimes called an Osler-Smith calculation. Sometimes it's called a bonus calculation. And so a percentage of that income going forward, and then there has to be determination of how long that might go on. But there can be support that's paid when that extra money comes into the picture. Divorce has its own encyclopedia, its own rules, and you will fare better. It's painful, but you will fare better if you can slow down a little bit, talk to each other, work with each other as best you can. And if you can't, then you have to get a litigated attorney and go to court. But do what you can to try to cooperate with each other, and then you'll spend less money and the outcome is likely to be better. And now it's time for us to hear from our real estate experts. And Jennifer and Emily, you're up. Thank you.
All right. Thanks so much, Cinda, for all that great information along with Ken. One thing we always like to say is that it's almost like drinking through a fire hose in these webinars. There's a lot of information coming at you. But one thing I do suggest is, again, we're here monthly and each month is a different topic. And Cinda just mentioned this, but I always say this: slow down in divorce. That is the number one thing that I can tell you, because all these different components that we're talking about, they all go hand in divorce. And all these professionals that you see should be in the realm of your team, whether it's us or somebody else in your area. You should be consulting all these people. And there's two reasons for that. One, property division. So in our realm, Emily and I's realm, as far as real estate, property division is final in divorce. You got one shot at this. And so what I see happens most of the time is people just want to rush through divorce. They want to get to the other side as quickly as possible. And it's just overwhelming. I've been through this. I've been in your shoes. We all have different journeys in divorce because it's very different for each person's situation. But I've been in your shoes of divorce. I'm now remarried and on the other side. But I remember my brain wasn't working properly then. I'm in real estate. I've been in real estate for 22 years and I could not think. And so getting me to sit down and analyze one of my largest assets, which is the real estate home and investment properties we had, was almost impossible because I could not even think myself. And so this is why you need a team and people that can strategize with you and reverse engineer all these numbers and all this information that we're talking about, because there's really no way you can do it yourself. It's just, that is the truth in divorce. It's emotional. And again, you have one shot at it, so you've got to slow down. The other thing specific to tonight is tax rules, especially since they change all the time, drastically can affect the bottom line in your divorce. And so not reaching out to a CPA, not reaching out to a financial advisor, not reaching out to those types of people, and a certified lender is imperative. And I'm going to have Emily go through why that is. But it is imperative that you reach out to those professionals, because not only is it final, but the tax rules affect your bottom line. You need to know, do you sell this year? Do you delay the sale? What if you get divorced, how long are you going to keep the home? You have to reverse engineer the timelines and where you're going to be 2 years, 3 years, 5 years out. So, in saying all that was a mouthful, Emily, let's talk back and forth on a few things that specifically would affect somebody in the real estate sector. But first, before I say that,
Yeah.
why do they need to reach out to a divorce certified lender? You
Yeah,
Yeah,
absolutely.
they need to do it.
Yeah, yeah. Thanks, Jennifer. And that's so true what you just said, that you're in such a space of there's so much emotion involved in the separation of the two partners. But then also when you're dealing with, if there's children involved, there's other family members involved, adding in a third party or a team really allows us to remove the emotion from the situation and look at what the reality is. So when I talked it prior about the discovery period, and that's so important because it's really, I know that you've worked with a lot of men and women that are just so emotionally tied to the home because that's where they first met, that's where they built their future, maybe had their children. And when that no longer either isn't a possibility or maybe it is, but maybe one partner isn't financially ready to take over that property. I think we've both seen situations where they're so emotionally involved in the family home that a year or two from the acquisition or the buyout from the spouse, they're in trouble and they're just underwater and they're hurting. And it's been a terrible 12 months, 24 months, and it's time to sell. So I think it's so important to really have us in the very beginning to say, is this really realistically something that you can keep up with? It's not just the principal and the interest and the property taxes and the insurance. It's the upkeep of the home. Is there a pool? What if something breaks? What are there appliances? We all know keeping up with the house is a consistent endeavor. That I think is hugely important for people to see. And that's the first thing that we do is just do an income analysis, see what the possibilities are. We are at an interesting time in the market where we are seeing interest rates dip and improve since the COVID years. What's happened is a lot of people have just been staying tight. They haven't moved because they enjoyed low interest rates for a while. Maybe they even bought during when interest rates started to increase. But we have a lot of built up equity that's sitting in property right now. And in my heart, I feel like we're going to explode. This next like 26, 27 is going to be a very interesting time in real estate. But if you are a divorcing couple and you are looking at, oh my goodness, I can't maintain this home on my own, then maybe it is time to talk with someone like Jennifer. She can do an analysis on what that property is worth and how much equity you've built. It's such a beautiful time in that aspect. And maybe it is time that you both go halvesies on that and separate and buy something on your own or whatever makes sense that might be a little bit more affordable. Again, given that interest rates are dipping. So it's just a balance of number one, primarily, what are your goals now that you're doing things on your own or with your children? What are your goals? How can we accomplish that? What is the longevity of that dream? And can we make that happen for you?
Yeah, one of the things I like to talk now about people. So I basically give people an income, an expense, an income. Oh my gosh, a profit and loss statement. My brain is it's the income and expense report because for the first time ever through divorce, unfortunately, the unfortunate part of divorce is you have to treat your largest asset, your financial portfolio, like a business, not the emotional side of this is my home and I've had all these memories. You actually should not. The quicker you can move out of that, which is really, truly difficult. I get it. I was there. I built my dream home. I had an ocean view and I left all of that because I had to. And so the quicker you can get out of that emotional entanglement with the home, the better you will be off in the future because even if it ends up being you can stay, that's great. But you need to run the numbers like a business. And so one of the things that Cinda talked about, but I'm going to talk about it again because it's a really confusing topic, and that is capital gains. And really, you need to just reach out to your CPA. But when you sell a home, if the sale price is higher than what you paid for it, that's really just the basic rule of capital gains, you will have experienced a gain. So if it's higher than what you bought it for and you're selling it at X amount of price, you bought it for 500,000, you're selling it for $1 million, that is a gain. Now, what do you do with the gain? There's ways that you can get around that. And there's two exemptions. One being single is $250,000 exemption, and one being married is 200 or is a $500,000 exemption if you're married. But you have to have owned it as your primary residence for 2 out of the last 5 years. So, why is that important in divorce? It's incredibly important if you need that exemption of 500,000 because you need to figure out what you're doing in the future. So, for an example, I'm going to give you an example. I had a client that decided to keep the home, then realized she couldn't actually keep the home because it was too large. Everything that Emily just said, she didn't run all those numbers. The yard was 2 acres. She had no idea how to keep up with it, didn't want to hire people. It cost too much. So she realized pretty quickly her husband had already moved on. And at this point, it was a few years later. And now all of a sudden, you've held on to a property trying and bleeding money for a long time because you don't know what to do and you don't want to be in her brain. I don't want to leave my dream home. I just wanted the home. She was so emotional in the divorce of just keeping the home that she did not look about at the entire big picture and didn't run the numbers. So what happened is that $500,000 exemption went down to 250 after 2 years, and that was an $80,000 difference. So if she would have just reverse engineered that, realized she couldn't have kept that home, then she would have had $80,000 in her pocket because she would have sold it while she was still married and received that exemption, or if she had owned it with him in the last 2 out of the 5 years. So it's a huge thing to think about. You really need to run those numbers with the CPA and reverse engineer those numbers. Another thing that people forget about, and what I want to talk about with Emily, is Prop 19. It is an asset, I believe, that people don't talk about. It's a hidden asset in a home because if you are 55 years or older, you can keep the tax base of your home. So if you've owned your home for 20 and 30 years, we live in San Diego. That's a
Huge, yeah.
difference.
Yeah.
You could be paying $2,000 or $1,000 in property taxes and would be paying 20 grand. It's a massive spread. And so if you're over 55 and you sell the home, you can keep that property tax base up to 3 times. You can buy 3 more properties. But what happens in divorce is people don't talk about it. It's not brought up in their discussions of divorce. And so it's an asset. It's somebody, the person that's staying, that's keeping the home, has an additional asset. Sorry to tell you, but you are holding on to potentially $20,000. So you have to use that in your divorce. If you're that out spouse, the one leaving, that person that's keeping the home not only gets the equity upside and gain of the home that you're walking away from, but they also get that property tax base if you're 55 and over. Now, if you're the person leaving, or let's decide you decide to both sell, it is first come, first serve. And that's what's not discussed. You need to discuss if you are selling your home in divorce, who's going to get that? Because only one person can get it, and it's first come, first serve. And you have to register with the in San Diego for in any county, you have to register for that. And this is California, by the way. So if you're out of California, this does not apply to you. But so Emily, I'm sure it's a massive, it changes somebody's qualification if they have a tax base built in that's only $1,000, doesn't it?
Yeah, it definitely does. And that's a huge point. And I think a lot of partners going through a divorce, they look at just, oh my gosh, I've got this much equity. We're going to split it in 2, and then we're going to go off in our merry way. And then they're hit with tax bills later. And that's crushing. It's just crushing for people. So just knowing this advice up front is so vital to their futures. Another thing that we had talked about offline was the 1030 exchange. People have it in their mind. I know Jennifer's experienced this. I've experienced this too, which is maybe bad tax information, but you cannot 1031 on your primary property. So 1031s only happen on investment properties. So if you do own a property as a couple and you're liquidating your assets and selling that, yes, a 1031 might make sense. And then you would take your profit from that rental property and separate that profit and buy something different. And that would be moving into a tax-free new investment property. But 1031 exchanges don't exist for primary properties. So that's a huge factor. And you had mentioned living in California. Yes, we live in an amazing state. And yes, we grow equity like no other. I invest outside of California, and I don't see equity built like we do here anywhere. So maybe New York City, but other than that. So it is very important for us to know the tax laws and Prop 19, like all of these things, because as a novice and you're going through this, and like we talked about earlier, there's a lot of emotions involved, and there's the family home, and there's children possibly. And like Jennifer said, maybe you're not quite thinking straight. It's just, it's a haze. To have a team, I think every time that I hear Cinda and Ken speak, I learn something new, even after being on these webinars for so many times. They're just so educated. They're just the masters of their field, as Jennifer is. And it's just invaluable to have all these partners in play for you, that we're here to help. We're here. All of us have been through divorce in one facet or another, whether it's like a family member, parents, in my case, and Jennifer firsthand. It's really difficult for the family. But if you have a really strong team, it is so much more manageable. It really is. And not only emotionally, but just to save you with decisions that you might make now in the middle of things for years and years to come, for not only you, but your children. It's so important. I love this team listening, and it's great that you're here.
Yeah, absolutely. And I'll end too with piggyback on what you just said too, Emily, because one thing is people don't realize the difference between a real estate agent or a lender and then a divorce certified real estate agent and a lender. And Emily touched on it. In divorce, you actually need more of a strategist than somebody coming in that's just going to say, I want to list your home. That's really not what I do. I evaluate and I like to that if I evaluate it and you have to sell, that you're going to come back to me. But that is not what I even start with. I want you to keep the home. And so if you go to a divorce certified lender or a real estate agent, our job is to strategize with you on how to keep the home. How are you going to equalize, meaning split the home 50-50-50 in California, we're 50-50, or however you work it in your marital settlement agreement. However, you're going to equalize, if you need to withdraw funds from your home or refinance or figure that out or trade properties, however you decide to equalize, my job is to help you strategize that for your future. And the reason why I do that, and it's complementary. And the reason why I do that is two different reasons. One, I do a lot of business with these divorce professionals. So that is why we're all in this hub, because we work all really well together and I get business through them. So that's amazing. The second reason is, if I'm helping you through one of the hardest times in your life, I guarantee I'm going to be the person that you reach out to in the future, whether you want to buy, sell, or even refer me. I've had 2 referrals of a divorced couple's parents because I helped the divorced couple figure out strategy-wise how to keep the home. And then they referred me with their parents. So to me, it's a service that I'm passionate about because I went through it and I know what it's like. And so that's why we do that. So I just wanted to say that because I have a lot of people go, why do you do this complimentary? It just doesn't make sense. That's the breakdown of it. All right. So we have 15 more minutes and we've got 22 questions. So I'm going to bring back the team. We're probably not going to be able to get to all of these, but we're going to try to answer as many as possible. And I'll just run through these and maybe do some skip arounds. And some of these are very specific and personal. And the only thing we can't do, as I mentioned at the very beginning, is we cannot give you very specific personal advice. That's if you want to, and the caveat to that is we all offer complimentary consultations. So after this, tomorrow, you'll most likely in the next few days get a call from Vesta Concierge, and they can connect you with anyone that you need to speak to maybe have a little bit more specific call. Am I responsible to let the IRS know that my spouse moved and didn't give me a forwarding address? Am I responsible to let the IRS know that my spouse moved and didn't give me a forwarding address? That really is outside of your MSA and anything that's going on with here. But is that a thing? Like if you're married and you should call the IRS?
I don't know. I think you should check with the CPA. But what I do know is that each person has the right to file separately. And so when the other person disappears and you don't have their information, then that does present a quandary. So I suggest you talk to a tax preparer about that.
Yeah.
Okay. All right. So if I do not file my financial disclosure response on time, the person is over 6 months late. What are the ramifications?
Like technically you're supposed to file it within 60 days of either filing your petition or your response. And the law says that there can be a demand from the other side to do it. And if you don't, you can get sanctioned, meaning the court can fine you money and such. So those are the potential ramifications. It's not instantaneous, meaning day 61 rolls around and you get crushed with sanctions. That's not going to happen. But the longer that goes on, though, definitely don't let it keep festering because your case is essentially dead in the water until those financial disclosures are done. The longer that goes on, the longer the case is going to go on. And then it's giving grounds to the other side to start arguing that you're doing things to keep the case from progressing. And maybe that should be held against you with regards to sanctions and such. Short answer is just get it done as soon as you can.
Sometimes
Okay.
people, they get so wound up because they don't know.
It
And
is
so they
overwhelming.
don't
You're right.
lie. But it's okay to say, I don't know. This is what I know.
That's an excellent point, Cindy, because I get that a lot. And this week, ironically, I was dealing with that with a client because it's one of those situations many times, it's a bad thing. And just a lot of marriages are such that one spouse did all the heavy lifting with the finances and one didn't. They did other stuff. That's how the teamwork functioned. But just because you don't know doesn't mean you're going to be penalized for that. And there's many times in that situation where we'll put on the disclosures that we believe other spouse has XYZ, but they have possession of all the document and access. So it's a good faith answer that you can put down and not be afraid of being penalized for.
Okay. Do you have a recommended team of professionals you typically see for an amicable divorce with no children, they own a home, and have 401k and investments?
A good mediator. I'm not trying to be glib about it, but
Yeah.
if Laura was here, I'd say she'd be fantastic for that because even if the case is complicated, a good mediator can get it to the finish line. But based on that fact pattern, that's the type when I tell people that fact pattern, it'd be a tragedy for you guys to even see the inside of a courtroom, unless you want to financially destroy each other, which sadly there's cases like that. But a good divorce mediator should be able to help you get that
And Laura,
resolved. And
Laura's amazing too. I'm sure we could come.
fantastic.
Yeah. Laura's amazing.
And all she does is divorce mediation. I'll put this out there because I get a lot of questions about different mediators. I know there's different mediators who do like dog bite cases and HOA disputes and divorce cases. And that's cool. I'm not trying to disparage them, but family law and divorces being as complicated and unique as they are, my recommendation would be no matter who you pick, make sure that divorce mediation is all they do. That's my 2 cents on that.
And it's not a good idea to go to, I'm sorry, I have to say it, but sometimes people say, we'll make our own agreement, we'll go to a paralegal.
Oh, I know.
Those
Yeah.
are the messes
It's
that we
risky.
see.
I have somebody like that right now. Is it true that my husband and I, if I guess my husband and I come to an agreement on, oh, wait. So is it true that my husband and I can come to an agreement on our date of separation? Is it true that from that date, all earnings and spending are his and then the same for me?
The short answer is yes. So, yeah, you can come to an agreement on the date of separation. Absolutely. Just bear in mind that once everything's signed and submitted to the court as a judgment, you're not going to come back and get a crack at changing it. And yes, the general rule is yes, that anything from the date of separation, any earnings that are collected by either party as a separate property, anything that they spend on or any debts they get into are their separate responsibility. That can get a little fuzzy sometimes because there's a caveat to that because You'll see a case where one spouse goes out and buys a new car after the date of separation. And then they put down a chunk for the down payment. And they'll say, I got this after date of separation. So this is mine. I don't owe anything on it. But it turns out that they got the down payment out of a community account, which is clearly community money. Be aware of that aspect too. But as far as a rule of the timing and data separation, yes, those rules are correct.
Okay. What takes precedence when two different states, including California, is involved? If the other state does not require an MSA is agreed upon, can California override it and demand disclosure?
Frankly, I don't have enough facts to answer that.
Okay.
Because here's the bottom line. I'll say
Every state's
this.
different.
Yeah, not to get all complicated, but in the United States, we have this full faith and disclosure, or full faith and credit clause of the Constitution. So what that means is, if the question is asking, is there an existing divorce judgment from some state? Whatever state issues a divorce judgment, that's what's going to control. So I'm just making this up. If someone has a divorce judgment issued in Florida, they can't come to California to try to alter it. So if that's the question, whoever issued the divorce judgment, that's what controls. If the question is which state can I get divorced in, that depends on residency requirements and stuff.
So another one similar is if I live in California and my spouse moved out of state to Texas, which state rules govern divorce?
Yeah. So assuming that if one spouse stayed here, I'm sure they meet the residency requirement. California's residency requirements to be able to file for divorce is you have to have lived here for 6 months, and in the county, you're going to file for 3 months. I don't know what Texas is, but if he moved there, I'm assuming he probably meets their residency requirement. So at this point, it's a race to the courthouse, is what they call it. If he files first in Texas, he can serve her here, and then Texas owns it. If she files here in California, she can serve him in Texas, and California owns it. So that's your classic race to the courthouse situation.
All right. So I don't know this answer actually. So maybe Cinda, you do, but do both people have to have lived in the home for it to be considered a primary residence for the married capital gain exemption? What if they had a long-term separation and the other spouse lives in another state?
There's an exception in the code, but it should be written in the marital settlement agreement. It's the IRC 121. And even though one person has lived in it, it can have been considered the primary residence of the other person as long as they agree. And then you can use the $500,000 exemption. But it requires the cooperation of both people on the agreement of both people, because sometimes somebody will buy another piece of real estate, and it's not likely, if it's a short period of time, that they're going to have a big capital gain. But it is one of the exceptions in the IRS code that's connected to divorce.
Okay. So for Prop 19, if I stay in the house for 6 or more years and then I'm 59 and I sell it, I keep the property taxes. Yes. Yes. She said,
No.
or they said, in negotiations, I'm supposed to keep the house, but I have questions on it. So yes, if you keep the house and it's awarded to you in divorce and you keep it for 6 years and then you're 59, decide to sell it, you are the one that keeps the property taxes. That's what I was mentioning though, the out spouse, if they don't know about it, then it is what it is. But to me, they're giving you whatever it may be, call it 20 grand. And so I would negotiate that as the out spouse of getting some of that too, but that's all negotiable. So if I sold while married, then the entire property tax basis can be carried over to the next home with Prop 19, not just 50% of the basis. Prop 19 only goes to one person. So whoever negotiates it, and again, it's first come, first serve. So if you don't figure out who's going to use it, then you sell the house. Let's say one person goes into a rental and the other person decides to buy. That person's going to claim the Prop 19. So you should negotiate it. You should figure out who's using it. What if you both rent for 5 years and then all of a sudden I think there's a limit actually year wise, you have to use it, I think. But no, it's not 50%. It's only one person gets it.
Yeah.
Would you advise modifiable versus non-modifiable spousal support? I don't know if you can just.
Yes, that is the classic. It depends.
Okay. Yeah.
Yeah, it's a really unique case specific situation. The general concept between non-modifiability is sometimes if it fits the situation, parties will agree, okay, we're going to set spouse support for X amount of years. It'll expire in 3 years. I'm just making it up. And they'll say it's non-modifiable. That way the party receiving it doesn't have to worry about having it reduced if something happens regarding the payer. And the payer also has predictability as well, saying, I know that's the amount I'm going to have to pay, and I can plan on that without the recipient dragging me into court and saying they need more. But that really depends on an enormous amount of different situations. And without knowing all the exact particulars, there's no bright line rule to say you should always do modifiable or not modifiable. It's a really case specific determination.
All right, maybe one more. So, what about debt established after the separation? And does it have to be a legal separation or a date that I consider stopped being
Yeah.
married?
No, that's a good question because it highlights the confusion that happens a lot. Not because of anyone's fault, it's just the way it's phrased in the law. So the date of separation and legal separation are two completely different things in the world of divorce. Date of separation is what I talked about when I was talking about divorce process. That's whatever that date of separation is, whether you reach it by agreement or a trial or whatever that date of separation is, that's the date that marks the end of the community. So whatever debt either spouse incurs after that date of separation, that's their own debt that is not subject to being split with the other side. But data separation is different from legal separation. Legal separation is another option on ending your relationship or your marriage. So California offers either dissolution, which is divorce, or legal separation. And what legal separation is, it looks exactly like a divorce case. You've got the property division, child support, spousal support, if applicable, child custody visitation, all of that. It looks exactly the same. The only difference is once everything's done and said and done, and the judge has signed off on your judgment, you have a judgment of legal separation as opposed to dissolution. And what that means is you're still on paper legally married. And there's only been like once or twice in my entire time doing this that I've had a case like that. And the cases that I've seen that people want that is either number one, they have a very deep religious conviction that divorce is morally wrong. So they want to be done with their partner. But at the end, when it's all said and done, they're still legally on paper married. So it satisfies that. The other situation I've seen is where one spouse is getting some type of pretty expensive medical treatment and the other spouse has really good health insurance. And if they got divorced, that would require the spouse receiving the treatment and benefits to lose all of that co-payments and insurance payments. So they come to an agreement saying, let's just do the legal separation. That way, even though we're done with each other, you can still stay on my insurance. My understanding is that's falling out of vogue because I think insurance
It's
companies are
hard.
getting wise to
It's
it and
hard to
not
do.
letting that happen anymore. But the last one I did was like years and years ago. But I think you have more current knowledge on that, Cinda.
You just have to ask because an example I can give you is a school district where before you could be legally separated and the school district would pay, or you could still keep the person with the serious medical conditions on your medical.
Okay.
But then the person went and asked, and the rules had changed, and they said, no, if you're legally separated for us and paying benefits, it's going to be the same as divorce.
Okay.
So you just have to be careful. But people can postpone a divorce for a
It's a
while,
good point. They can defer
right?
the actual effective date. Yeah.
Yeah.
All right. I think that's to the other. We didn't get to all the questions, but to everyone else, like I said, some of it was too specific. It's a little hard to answer in this format. So please reach out to Vesta Concierge and you can book consultations. Thank you, everyone, for your time tonight. We really appreciate it. And hopefully, we gave you a ton of information. And thanks for showing up.
Good night, everyone.
Everyone, have a great night.